Hello, Legal Eagles! I wanted to give you a quick legal update on the Abrego Garcia case because two extraordinary things happened since we released our fairly comprehensive video yesterday. In yesterday's video, which I'll leave a link to, we covered basically everything that happened from Mr. Abrego Garcia's erroneous deportation from Maryland to his extraordinary rendition to the CCOT gulag in El Salvador, literally the one country he couldn't be deported to. And we talked about how the district court judge is absolutely furious and has ordered expedited discovery, specifically the depositions, meaning the questioning under oath of the government witnesses, some of whom are lawyers for the government, and how it looks like the judge is not going to entertain objections to privilege, even though these are lawyers because they were put forward as fact witnesses. Well, the latest government affiant, who previously filed a declaration under oath, apparently realizes he's in trouble and doesn't want to say more things that will get him into yet more trouble. Joseph Mazzara, acting general counsel for Homeland Security, filed a new status update with the court. And all it says is, I, Joseph N. Mazzara, declare under penalty of perjury as follows. 1. Please refer to my prior declarations for the foundation of my personal knowledge. Which is funny because, as we talked about, I'd argue those declarations do not establish personal knowledge in any way. And then he goes on to say, quote, 2, given the government's prior clear and unequivocal notice to the court regarding how the government will facilitate Abrego Garcia's return within the contours of existing law and regulation, there are no further updates. So yeah, they are really doubling down on the whole we're not going to do anything and you can pound sand approach. And the judge is not going to like that. But the second thing that happened is perhaps even more extraordinary. While all of this was going on, the government asked the Fourth Circuit Court of Appeals for a stay of the judge's order. But the Fourth Circuit moved lightning fast and denied the government's request, so things are proceeding in the district court. Judge Wilkinson wrote the order, and one of the extraordinary things about this order is the language that he used, but the other is the source. Judge Wilkinson is a Reagan appointee who tends to be maximally deferential to assertions of executive power. But Judge Wilkinson did not mince words. He says, quote, upon review of the government's motion, the court denies the motion for an emergency stay pending appeal and for a writ of mandamus. The relief the government is requesting is both extraordinary and premature. While we fully respect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. It is difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, there is nothing that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. That would allow sensitive diplomatic negotiations to be removed from public view. It would recognize as well that the facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. The Supreme Court's decision does not, however, allow the government to do essentially nothing. It requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Facilitate is an active verb. It requires that steps be taken, as the Supreme Court has made perfectly clear. Facilitation does not permit the admittedly erroneous deportation of an individual to the one country's prisons that the withholding order forbids, and further, to do so in disregard of a court order that the government not so subtly spurns. Facilitation does not sanction the abrogation of habeas corpus through the transfer of custody to foreign detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would reduce the rule of law to lawlessness and tarnish the very rules for which Americans of diverse views and persuasions have always stood. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and detachment, we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law and time will sign its epitaph. It is, as we have noted, all too possible to see in this case an incipient crisis. But it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. I don't know, I thought that was worth flagging and updating yesterday's video. Given the author, this may have been written specifically for the members of the Supreme Court who are basically putting their heads in the sand to what the executive is currently doing. But it's also a sign that judges are taking this seriously. I realize if it's frustrating that if the Trump administration is going to be completely intransigent, it's going to take some time to force them to course correct. Still, given that the executive currently isn't stopping and is in fact scouring social media to punish speech it doesn't like, now might be a good time to scrub as much personal information from the internet as possible, which you can do with the help of today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. And you can use my link in the description or the code LegalEagle for an exclusive 60% off discount. Now, these data brokers are the reason why in the United States, you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It might also be why you're getting so many spam calls lately and even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and in that time, you can see that I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if your data broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. You can click on the link that's on screen or down below to try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court. It's possible that Marvel might lose the rights to some of its most popular characters, Spider-Man, Black Widow, Thor, and Iron Man, among others. It's possible they might be ripped right out of the MCU, because copyright is weird. But Marvel is being proactive. That's why they're going to court to stop the heirs of the creators of some of its most iconic characters from getting any royalties. With these lawsuits, Marvel is arguing that characters created by geniuses like Stan Lee are ineligible for copyright termination because they were works made for hire. In other words, since Lee was a Marvel employee, his estate is not entitled to any of the profits from future TV, movies, and merchandise. And Marvel makes the same argument against Steve Ditko, Gene Colan, and Larry Lieber, or their estates. Ditko, of course, is the reclusive legend who created Spider-Man with Stan Lee. Colan is the genius behind Daredevil, Falcon, Carol Danvers as Mrs. Marvel, and the cult satire Howard the Duck. Lieber drew newspaper strips of the Incredible Hulk and the Amazing Spider-Man and was instrumental in creating Iron Man. Marvel is still making movies and TV shows featuring these characters, and they are a big part of Disney's long-term plan. Well, maybe not Howard the Duck, at least not yet, but if that dog killer Cruella de Vil can get a favorable origin story, we know that Howard the Duck probably can't be too far behind.
That's it. No more Mr. Nice Duck.
But this is no small matter. If Marvel loses these lawsuits, its parent company Disney would have to share ownership of these characters that are worth billions of dollars. Hey Legal Eagles, it's time to think like a copyright lawyer. So let's talk about why is Marvel suing the creators of some of its most famous characters and what's at stake. Well, let's take a look at what prompted Marvel to file these lawsuits. Steve Ditko was a renowned comic book artist who collaborated with Stan Lee to create Spider-Man and Doctor Strange. And unlike Lee, Ditko was a recluse who preferred to live in privacy, much like author J.D. Salinger. In his post-Marvel career, Ditko invented cult favorites like Squirrel Girl and wrote several comics featuring objectivist characters modeled on the philosophy of Ayn Rand. Ditko lived and worked alone in a Manhattan studio until his death at the age of 90 in 2018. Now, no one knows what Ditko worked on in his last years, but his last published words came in 2019. Quote, "Here's to those who wish me well, and those that don't can go to hell." And in this case, those who can go to hell might include Marvel and Disney.
Oh dear, what an awkward situation.
Now, this isn't always the case, but sometimes there are terminations provisions under copyright law where authors or their heirs can reclaim rights once granted to publishers after waiting a statutorily set period of time. Ditko's heirs in this case include his brother and his nephew. In August, his estate filed a notice of termination on Spider-Man. The Ditko termination notice demands that Marvel must relinquish Ditko's rights in Spider-Man by June of 2023. And there are termination provisions potentially at issue with a whole host of some of Marvel's most famous characters. So just what is a termination provision in US copyright law? Well, copyright termination is the termination of a grant or transfer of someone's copyright rights. And the Copyright Act of 1976 lengthened the term of copyright protection, giving copyright owners even more time to control and profit from their works of art. This was the major policy accomplishment of Congressman Sonny Bono, otherwise known as one half of Sonny and Cher. Yes, he did go on from the duo to hold office in Congress. And many people have either blamed or congratulated Disney on this extension of the copyright term. But note that not all copyright holders are the original creators of the art. For example, Paul McCartney co-wrote some of the most memorable songs ever written, but over the years he sold or lost the copyright to that material. Most of the Beatles catalog is currently owned by Sony ATV, which acquired a good chunk of it from the estate of Michael Jackson, who famously purchased them for $47 million. Yeah! In 2018, McCartney filed termination notices to reclaim those Beatles copyrights. Eventually, he settled with Sony ATV. A decision on the merits of that case would have been a landmark ruling, but both sides obviously felt there was too much to risk to proceed. And with the value of the Beatles' publishing rights over $1 billion, there's plenty of money to go around. Now, creators can lose or voluntarily assign rights in a number of different ways, including just entering into a contract that seemed fair at the time, but in retrospect turned out to be very one-sided. Now, the amended Copyright Act therefore gave some artists the chance to get their copyrights back, provided that they lost their rights on or before January 1st, 1978. So the idea was that Congress is extending the copyright term, so if you had a copyright and then transferred it to somebody else before 1978, then you were allowed to claw back that copyright assignment or transfer many decades later. And now a lot of those terms are coming due. Following termination, any rights transferred under the grant come back to the person who created the copyrighted work. The purpose of this provision is to let authors, musicians, and illustrators and other artists renegotiate the terms of their original contractual agreements. It basically gives artists a second chance to get a better deal. If the author is living, like Larry Leiber, they can file a termination notice at the appropriate time. Leiber is Stan Lee's little brother. He's responsible for co-creating Ant-Man, Thor, and Iron Man. Marvel is suing Leiber to stop him from terminating the Marvel copyrights to these characters, or in other words, Marvel is going to court to say that in this situation, the termination provisions don't apply and the rights therefore don't have to go anywhere else. But not all rights return after a successful termination. Creators' American rights revert, but foreign rights, which are usually negotiated separately, do not return to the creator. Derivative works created under the authority of the grant before its termination can continue to be exploited. And as you can see, this is a more complex situation than it first appears. So let's dive into the Copyright Act provisions at stake, 17 U.S.C. 203 and 304. The first question that arises is which works are eligible for termination. Although most grants of copyright rights can be terminated, some grants are excluded. Since the termination provisions are meant to give the author a second chance, if the author is still living and the original grants were made by somebody else, these grants can't be terminated. If the author is living, grants made by anyone other than certain statutory heirs are also ineligible for termination. The list of individuals is included in Section 304. And the Act also excludes grants made by will. So if an author died 50 years ago and granted their copyrights to someone by will, that person's heirs can't attempt to revoke the grant under this section. Additionally, and this is the big one, the Copyright Act's termination provisions do not apply to works made for hire. A work made for hire has a complicated definition, but generally speaking, if you're employed when you make something that could be copyrighted, it's your employer who gets the copyright to that thing. It's not the employee who made that thing while being employed by somebody else. And if a work is made for hire, an employer is considered the author even if the employee actually created the work. The employer can be a firm, an organization, or an individual. This is a very contentious part of the law for comic book creators, many of whom were actually employees when they created their characters. And determining whether something is a work for hire is challenging and depends on the facts of each particular situation. Now, there are some complications in when a termination notice needs to be provided. I won't bore you with the details, but it generally has to fall within a 5-year termination period. And here, the Marvel cases mostly involve grants executed before January 1st, 1978. And in addition to the timing, there are tons of procedural issues like co-ownership. A majority of the co-owners have to agree. There are lots and lots of procedural issues here that are extremely boring and have no place in a 15-minute YouTube video. And other creators have filed termination notices as well. They tend to be represented by attorney Mark Toberoff, the lawyer who represented Superman creators Jerry Siegel and Joe Shuster, in their ultimately unsuccessful termination attempt against DC Comics. Now, under some circumstances, a would-be defendant can go into court and get the court to adjudicate the issue before everything goes crazy. And that's what Marvel has done here. Marvel has filed suit against the creators, alleging that they were all employees and that the works that they created were considered works for hire and thus not subject to copyright termination. Marvel is asking federal courts in New York and California to issue declaratory judgments, blocking the termination notices and affirming that Disney is the sole owner of these characters. So you might see headlines that Disney is suing the owners, and it sounds nefarious, but there's really nothing wrong with it. They're adjudicating this case early, and while Disney would normally be the defendant in an action like this, they're really just going to the court to adjudicate exactly the same things that they would if the creators were the ones that were suing Disney. Now, a lot of this litigation is going to turn on the definition of a work made for hire. That's defined by Section 101 of the Copyright Act, which defines a work made for hire in two parts. It can be either A, a work prepared by an employee within the scope of his or her employment, or B, a work specially ordered or commissioned for use as a contribution to a collective work, as part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional test, as an answer material for a test, or as an atlas if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. Now, the Supreme Court has interpreted a work for hire in the famous case of CCNV versus Reed. Now, in that case, the Community for Creative Nonviolence made an oral agreement with James Reed, a sculptor, to produce a statue depicting the plight of the homeless for display in a 1985 Washington, D.C. Christmas pageant. After the sculpture was completed and delivered, CCNV paid Reed in full. Shortly after that, both parties filed separate and competing copyright claims over the sculpture. A lower court held that the sculpture was a work made for hire. And after the Second Circuit reversed the decision, it went all the way to the Supreme Court. And the Supreme Court ruled for Reed, the sculptor, holding that the court must first ascertain whether the work was prepared by an employee or an independent contractor. If an employee created the work, part 1 of the definition that we talked about applies, and the work will generally be considered a work made for hire because it was made within the scope of that person's employment. But this gets more complicated because the term employee in the definition differs from the common understanding of the term. For purposes of the Copyright Act, an employee means an employee under the general common law of agency. If an independent contractor created the work, then the work was specially ordered or commissioned. Part 2 of the definition applies. And an independent contractor is someone who was not an employee under the general common law of agency. And the Supreme Court created 4 factors to determine whether someone is an employee under purposes of the Copyright Act. I won't bore you with those definitions, but you can actually read it in CCNV versus Reed. It's actually a pretty understandable court decision as those things go. But in this litigation, it will probably focus on what's called the Marvel method, which is a, quote, loose collaborative working atmosphere where initial ideas were briefly discussed with artists responsible for taking care of the details. Marvel characterizes this as a traditional employer-employee relationship. And Marvel argues that any contributions that Steve Ditko, for example, made were at Marvel's instance and expense. Marvel editorial staff had the right to exercise creative control over Steve Ditko's contributions, and Marvel paid Steve Ditko a per-page rate for his contributions. When Steve Ditko worked for Marvel, he did so with the expectation that Marvel would pay him. Moreover, Marvel says that its editorial staff had the right to exercise creative control over Steve Ditko's contributions. Quote, any contributions Steve Ditko made to the works were done at Marvel's expense because Marvel paid Steve Ditko a per-page rate for his contributions. Steve Ditko made those contributions to the works with the expectation that Marvel would pay him, and Steve Ditko did not obtain any ownership interest in or to his contributions. And Marvel made the same arguments in the other lawsuits as well. And the representatives of the comic book creators will make the same legal arguments that Jack Kirby did over a decade ago when Kirby and Marvel litigated the issue of whether Kirby could terminate a copyright grant on Spider-Man, X-Men, The Incredible Hulk, and Mighty Thor. In 2013, the Second Circuit Court of Appeals affirmed a lower court ruling that Kirby's heirs could not terminate the copyright over those characters since Kirby had contributed his materials as a work made for hire. Kirby tried to appeal to the Supreme Court, arguing that he was essentially a freelancer, not an employee. Kirby didn't receive any benefits or fixed salary, nor did Marvel reimburse him for his expenses. Kirby also worked from home, and although this would seem to suggest that he was an independent contractor, the Second Circuit saw the situation differently. Quote, despite the absence of a formal employment agreement, however, the record suggests that Kirby and Marvel were closely affiliated during the relevant time period. Lee assigned Kirby, whom he considered his best artist, a steady stream of work during that period. And Kirby seems to have done most of his work with Marvel projects in mind. The Second Circuit emphasized that the key factor is whether a work is made at the hiring party's instance and expense. And that happens when the employer induces the creation of the work and has the right to direct and supervise the manner in which the work is carried out. The Second Circuit acknowledged that Kirby's, quote, working relationship with Marvel between the years of 1958 and 1963 was close and continuous, and continued, quote, understood as products of the overarching relationship, Kirby's works during this period were hardly self-directed projects in which he hoped Marvel, as one of several potential publishers, might have an interest. Rather, he created the relevant works pursuant to Marvel's assignment or with Marvel's specifically in mind. Kirby's ongoing partnership with Marvel, however unbalanced and under-remunerative to the artist, is therefore what induced Kirby's creation of the works. It's believed that Kirby had a looser agreement with Marvel than many other artists, including Lee. And when the Supreme Court declined to accept the appeal from the Kirby case, the parties settled. And since the ruling only applied to 2 of Kirby's 4 children, the others lived in California, Marvel opted to settle with the family rather than face more litigation. So this probably means that Marvel has the edge because of this published Second Circuit ruling. In the current cases, Marvel argues that the Kirby case is dispositive and that the courts must rule in its favor. However, the ultimate issue of whether the Marvel method of producing comics means that the creators were employees still hasn't been decided by the Supreme Court. And one of the most important factors in determining whether you are an employee or an independent contractor is whether your employer provides you with the tools you need for the job. And if your employer doesn't give you a cell phone, you can save a ton of money on your cell phone bill with today's sponsor, Ting Mobile. In fact, I personally switched to Ting Mobile and saved literally hundreds of dollars a month. I'm not kidding about that. Why? Well, because of this. Yes, this is a real cell phone bill that I got with my previous provider, and that's why I personally switched to Ting. And Ting Mobile has 3 brand new plans to make sure that that never happens again. All of Ting's plans have unlimited talk and text starting at just $10 per month, so you can use the Flex plan and only pay for what you use, which is especially great if you're around Wi-Fi all day. You can choose a set of 12 gigabyte of data for $35 or get full unlimited for $45 a month. Switching plans is actually really easy because you can keep your same phone number and use pretty much any phone. And the service is great too because Ting partners with several massive networks, probably the very same one that you're using right now, but at a huge discount. They literally use the same infrastructure. Now, I actually can't tell you which ones because I always respect contract, but let's just say that my service hasn't changed at all, and you get the benefit of other massive networks as well. And if you're around Wi-Fi all the time, like you're working from home, you have the flexibility to save hundreds of dollars a year. That's because Ting still gives you the option to just pay for what you use with their Flex plan. Now they just give you the possibility of unlimited versions as well. So if you want unlimited, you can go absolutely crazy. And it's incredibly easy to transfer service. All you have to do is just order a Ting SIM card, pop it in, and set it up. No phone calls are required. It's like magic. But if you do want to talk to Ting, you can call them up and immediately talk to a real human being, or you can talk to them on chat or Discord. You'll talk to real human beings, not AI robots. Virtually no wait times because they don't have brick and mortar stores. They pour it all into their customer service. Now, if you'd like to give Ting a try, Legal Eagles will get a free $25 service credit that could cover 2 months of service. All you have to do is click on the link below and give it a try. You can even use your last bill to compare just how much you would save. All you have to do is click on the link that's on screen right now. Plus, clicking on that link really helps out this channel. And while you're there, check out this playlist with all my other real law reviews on the most important legal issues of the day. So click on this playlist, or I'll see you in court. The FBI raided Trump's house at Mar-a-Lago. Well, the FBI executed a search warrant and took a bunch of documents and things. But yes, this is unprecedented in America. Yes, it could be the beginning of a criminal prosecution of the former president. Yes, it could be the tip of the spear of a political witch hunt by the Biden administration against a political rival. Or it could be a mundane effort to retrieve archival documents that leads to absolutely nothing else. We just don't know.
The FBI, and I give them a lot of credit because they're fighting forces that they're not supposed to be fighting.
But what do we know about the search warrant that was carried out against former President Trump? We can't make many assumptions about the FBI raid until we see the actual warrant or until, we see an indictment. But here's what we do know. The Justice Department is conducting at least 2 investigations that we know of into Trump. The DOJ is looking at his attempt to overturn the result of the 2020 presidential election and is also investigating the alleged mishandling of classified records. The National Archive is charged with collecting and sorting presidential material. The National Archives has publicly stated that it had to recover at least 15 boxes of White House records that Trump took to his Mar-a-Lago resort. The records include some classified material. And we know that Trump has a history of destroying and withholding records. He was repeatedly warned about destroying documents, but according to CNN, Politico, and the Washington Post, he tore them up and threw them in the trash or on the floor. White House officials reassembled some of those records with tape. The National Archives confirmed that the Trump administration sent the archives some documents that had been taped back together, as well as records that were still in shreds. I'll be doing a separate video on the Presidential Records Act and the implications of the Espionage Act, but multiple sources told CNN that in April and May, the FBI interviewed Trump's Mar-a-Lago aides, and in June of 2022, investigators visited Mar-a-Lago to discuss Trump's removal of potentially classified material that had been taken to the Florida property. One of those investigators, Jay Bratt, is the chief of the Counterintelligence and Export Control Section at the Justice Department. Trump reportedly greeted the investigators but did not answer questions. The investigators asked to see where the documents were being stored. Trump's lawyers showed them a room in the basement where boxes of records were being stored. Some reports said that the documents were marked with top secret. On June 8th, the investigators sent a letter to Trump's lawyers telling them to secure the room where the secret documents were stored. Trump aides complied with the request and added a padlock to the door. Now, I probably don't need to tell you just how insane it is that there could be top secret classified documents being stored in some basement in Mar-a-Lago, or just how insane it is that the FBI raided Mar-a-Lago potentially over these documents. But I do have to say that they even broke into my safe is probably going to go down as a quote for the ages. But the search began early Monday morning and apparently focused on the area of the club where Trump's offices and personal quarters are located. The investigators met with two of Trump's attorneys, and Trump reportedly greeted the investigators but did not answer questions. Investigators removed more than a dozen boxes of items. Eric Trump told Fox News that he was told, quote, the purpose of the raid, from what they said, was because the National Archives wanted to, corroborate whether or not Donald Trump had any documents in his possession. Trump's lawyer, Christina Todd, said the FBI seized documents and Trump cooperated with the FBI. Quote, President Trump and his legal team have been cooperative with the FBI and DOJ officials every step of the way. The FBI did conduct an unannounced raid and seized paper. Although Bob said that the raid was unannounced, CNN reported the FBI and Secret Service communicated about the raid before it happened to ensure that it went smoothly. Donald Trump was in New York on the day of the raid, and the Biden administration was reportedly not aware of the raid, according to CNN. Now, we can assume this raid did not happen at the behest of a rogue FBI agent or a local judge acting without buy-in or notification of high-level DOJ officials. Obviously, serving a warrant on a former president is an incredibly serious thing, and it's a decision that can't be taken lightly. The FBI and DOJ must follow constitutional and statutory requirements for obtaining a warrant, which we'll talk about in a moment. But in addition, the DOJ has guidelines for investigations of political targets. In 2020, former Attorney General William Barr issued a controversial memorandum stating that anyone in the Justice Department who was investigating a political candidate must run it by the Attorney General for approval. And current Attorney General Merrick Garland renewed that memo on May 25th, 2022. Garland's memo is titled Election Year Sensitivities. The memo reminded DOJ employees of the department's long-standing policy for avoiding steps that could be perceived as partisan and designed to influence an election result. Quote, this is particularly important in an election year. Now that the 2022 election season is upon us, and as in prior election cycles, I am using this memorandum to remind you of the department's existing policies with respect to political activities. Now, Barr's original memo says investigations, including preliminary ones, into presidential or vice presidential candidates, their campaigns, or staff cannot be opened without the written approval of the Attorney General. It also states that an investigation into a congressional candidate or campaign cannot be opened without first notifying the Assistant Attorney General and the respective U.S. Attorney in the district involved. And if an investigation is initiated in line with these guidelines, then the investigating agency has to provide regular updates to the Deputy Attorney General. Now, Trump has indicated that he will be a candidate for president in 2022. So the TLDR version here is the FBI would not have applied for a search warrant without Garland's consent, and presumably they also would have gotten approval from the Trump-appointed FBI Director Christopher Wray. But what is the requirement for a federal search warrant? Well, a search warrant authorizes law enforcement to search a location for any of the following: evidence of a crime, contraband, fruits of crime, or other items illegally possessed, property designed for use, intended for use, or used in committing a crime, or a person to be arrested, or a person who was unlawfully restrained. Now, usually those first three are lumped together. Imagine a simple burglary where jewelry was stolen. You'd want to look at the burglar's house for the stolen jewelry, cash or drugs that might have been traded for the stolen jewelry, or burglary tools. And so law enforcement has to identify two different things. One, the person or property to be searched, and two, the items to be seized. Now, more to the point, law enforcement has to establish probable cause to believe that the items to be seized exist and will be located in the person or property to be identified. And probable cause is hard to define. It's imprecise, fluid, and very dependent on context. The US Supreme Court says that finding whether probable cause exists is, quote, a practical common sense decision, whether given all the circumstances circumstances, there is a fair probability that contraband or evidence of a crime will be found in a particular place. And what does fair probability actually mean? Well, it doesn't have a specific number attached to it, unlike the standard of preponderance of the evidence, which is just a hair over 50% or more. That said, several studies over the decades that involved surveys of judges generally agree the probable cause is somewhere in the high 40s, but beneath 50%. And it might be worth noting that some jurisdictions like Oregon have collapsed the probable cause standard and the preponderance standard so that probable cause means anything over 50% likelihood. But that is not the federal or constitutional standard. The constitutional standard is only a fair probability. Now you might ask, how specific does a federal search warrant have to be? Well, generally speaking, not that specific. We can look to the search warrant that was used against Paul Manafort. It includes something very specific, quote, a Bijon black titanium Royal Way watch. But it also includes general categories of items like any and all financial records for Paul Manafort Jr. Now we'll get into what that means in practice later, but let's talk about the practice for getting a federal search warrant. Now, the applicant for a search warrant is generally a federal law enforcement officer of some kind, an FBI agent, a Treasury agent, etc. And as of 2016, federal agencies employed about 132,000 full-time law enforcement officers. And every federal search warrant is reviewed by an assistant U.S. attorney of some kind. Now, that's not required by law, but it's a policy decision by the Department of Justice. Now, the application itself is a one-page template, and federal law enforcement generally attaches 3 documents to that application. The first is the affidavit by the investigating officer. Attachment A includes the property to be searched, and Attachment B lists the items to be seized. Now, the affidavit is a sworn declaration by the law enforcement officer that sets forth the officer's knowledge of the investigation. It can include hearsay and even information from anonymous or confidential sources, though the officer needs to establish the reliability of that information. The purpose of that affidavit is to establish probable cause to the reviewing magistrate. But the affidavit is all there is. The magistrate does not get to consider any additional information, just what's contained within the 4 corners of that document. Now that said, the magistrate judge has to issue the warrant if there is probable cause. It's not optional. The judge does not have discretion to say, well, there is probably probable cause, but I don't think you need it for your investigation. It's looking pretty good on its own. Once the magistrate judge has found probable cause, the warrant must issue. And what this means in practice is that the magistrate judge signs the application, the one-page template, and issues it to another officer authorized to execute it. The warrant must be executed within 14 days and during the daytime unless there's good cause to execute it at some other time. And this should go without saying, but I'm gonna say it again anyway. Just because a judge signs off on it doesn't mean a crime has been committed. And just because you have received a federal search warrant doesn't mean that you are a criminal or have done really anything wrong. See contra all of the legal bad takes on Twitter. And as a reminder, just because a search warrant was executed on a particular person's property, that doesn't mean that particular person is the target of an investigation. Now, it is very common for that to be the case, but search warrants are frequently served on Google and Meta for information and data that they keep on their servers that are relevant to an investigation. They're not the target of that investigation. Now, and it's rare, but occasionally search warrants are executed on members of the media who have information or lawyers who represent the targets of an investigation. Nor does it mean there absolutely will be a prosecution. Just because there is probable cause doesn't mean that the government can prove a case beyond a reasonable doubt in a jury trial. That's a completely separate consideration in light of all of the evidence, including whatever evidence comes out as a result of the search warrant. The beyond a reasonable doubt standard is much higher than the probable cause or even the preponderance of the evidence standard. Though it's always good to remind people that just because you aren't convicted beyond a reasonable doubt doesn't mean you didn't commit a crime also. So it goes both ways. Now, there are some differences between state and federal courts when it comes to search warrants. For one, the states don't have a single uniform procedure like the federal courts do. Now, they all basically get you to the same place, but they certainly won't look as uniform as they do in the federal system. And state judges have a reputation for rubber stamping applications for search warrants. The federal system has the Department of Justice that acts as a gatekeeper for search warrants, even though that's not required by federal law. So state judges are more likely to get warrants that contain plenty of grammatical and formatting issues and might not have quite as much evidence as far as probable cause goes. But in any event, the end result is that officers will show up to a location, knocking on the door, notifying the people inside of the search warrant, and then searching the scene. That means getting everyone out of the place so that they can't tamper with evidence or present a threat. The officers then search the place in accordance with what's allowed in the warrant. They can search for the items authorized by the warrant and open any containers that could reasonably contain the items, including safes, lockboxes, and the like. And using the Paul Manafort search warrant as an example, we saw that there was a pretty big category, any and all financial records for Paul Manafort Jr. So let's say that you're one of the FBI agents on the scene. You would basically look for documents and papers. And let's say that you find a manila folder that contains 100 or so pages. You might skim through it, and as you do, you see a couple of financial records that pertain to Paul Manafort. You would then likely seize the entire manila folder. There are two reasons for this. One, people typically keep financial records with other financial records or related records, and those related records might be needed to make sense of the specific financial records that they're kept with. And second, you don't have time at the scene to fully understand how all the documents link together. In other words, you don't understand the import of those documents at the scene. So you'd probably take the entire manila folder and notate on an inventory form something like manila folder containing financial documents located in the lower right-hand desk drawer in the office. Now, agents keep an inventory of what items they seize and where they found those items. They are required by law to do this. When they're done executing the search warrant, they will leave a copy of the search warrant as well as a copy of the inventory of things seized. Now, it's important to note, they do not leave a copy of the affidavit. All they will leave is the one-page application along with the two attachments listing the property to be searched and the items to be seized. After that, the investigating officers would then return the search warrant to the magistrate, and it would specify the date and time the warrant was executed and include the inventory of items seized. So what's next? Well, Trump has a copy of the search warrant, but not the supporting affidavit. He could release it if he chose to. There's no legal reason why he couldn't release it. And it's interesting that he has chosen not to. And additionally, there are reports of a mole or informant inside of Mar-a-Lago, which might explain the exigency of the FBI search of Mar-a-Lago. Additionally, the Florida Times-Union, Judicial Watch, and the New York Times have filed a motion to unseal the records. The supporting affidavit is sealed to protect the investigation, and generally the DOJ doesn't comment on ongoing investigations because it could jeopardize the investigation and tip off other targets, or the target who is the initial target.
12 seconds later.
Except, of course, when the DOJ chooses that it's going to make a statement about an ongoing investigation, like when you're trying to get a friggin' YouTube video out and the Attorney General for the United States chooses to give a press conference. Duh! Attorney General Merrick Garland confirmed in a press conference that indeed he did have personal supervision over the search warrant that was executed over the former president's estate at Mar-a-Lago. And in fact, because former President Trump did confirm the search warrant was executed and publicly stated information about it, the DOJ is going to move to unseal the records related to the search warrant itself. One gets the sense that the DOJ was trying to keep this quiet. And in fact, this comes on the heels of a report from the New York Times that a subpoena was issued against former President Trump to return some or all of the documents in question, and that may have not been complied with, which might have forced the DOJ's hand to execute a search warrant to get these documents. And now we're facing the incredibly interesting situation where it's the DOJ that is moving to disclose this information, and it may be former President Trump who doesn't want it disclosed. He, of course, always had the ability to disclose the receipt and the other pages of the warrant, other than the probable cause affidavit, and now he may be in a situation where he wants to keep that secret. But at least that's likely to be the last bombshell that we have to deal with in this particular case for a while.
12 seconds later.
Are you friggin' kidding me? So the Washington Post is now reporting that the documents at issue here concern nuclear weapons, which explains a whole lot about why this search warrant was executed, why the exigent circumstances, and why everyone is freaking out. It also throws a huge curveball in the people that were saying that the president could just declassify documents on the way out of the White House. When it comes to nuclear weapons related documents, often that has to go through a separate regulatory agency. Often the president is in charge of declassification, but when it comes to these kinds of documents, that is not necessarily the case. It also raises all kinds of questions as to why former President Trump took these documents out of the White House and why he might have refused to turn them back over when multiple requests were made, which is what has been alleged. So we'll cover all of the potential criminal implications of this in a separate video, but this whole situation is raising all kinds of questions. But one thing is for sure, keeping a bunch of classified documents in a basement would be a pretty stupid move. But they could quickly get their brains back to functioning correctly with a logic or math course from today's sponsor, Brilliant. Brilliant is an online learning platform for STEM that replaces lecture videos with hands-on interactive lessons. Brilliant is for curious learners, both young and old, professional and inexperienced. You could quickly learn to ace your high school or college math courses, or just learn stuff you always wanted to. One of my favorite courses is all about logic. Brilliant's logic courses cover liar and truth-teller riddles, logical fallacies, machine logic, and even some strategic game theory. And logic is a crucial skill that lawyers and former presidents need every day. Brilliant statistics and finance classes are also extraordinary. Now, Brilliant lets you learn by doing rather than just listening to hours of boring lectures. Learning through doing is scientifically proven to be the most effective way to master any new skill. The courses have storytelling, interactive challenges, and problems to solve. So you can sign up and start learning today for free by clicking on the link that's on screen right now or in the description. The first 200 people to sign up will also get 20% off their annual subscriptions. So by clicking on the link that's on screen or the description, you'll get 20% off your subscription to Brilliant. Plus, clicking on that link really helps out this channel. And after that, click on this playlist for more LegalEagle, or I'll see you in court.
Oh my god, you guys, you asked for it, now you're getting it. LegalEagle is finally tackling the Roblox Schlepp situation. Now your boy Schlepp was going after the child predators Chris Hansen style, but then Roblox banned him. What? The state of Louisiana is suing Roblox. What? Also, millions of kids are being exploited on the Roblox platform as cheap or free child labor using a centuries-old racket of company script. There's a lot of legal nuance in this story, so listen up. Whoa. Are we horizontal now? That's harder than it looks. Roblox is a $1 billion online playground and creative sandbox with about 400 million active monthly users. About 40% of those users are under the age of 13. The YouTuber Schlepp earned a following in the millions by pretending to be a little kid and honey-trapping child predators in the game, and then exposing them on his channel to catch a predator style. He even uses images of Chris Hansen to confront his targets. But instead of celebrating Schlepp's vigilantism, the Roblox Corporation banned him from the platform, leading to widespread internet outrage.
Avengers!
California Congressman Ro Khanna put out a petition to force Roblox to do better by children on the site. And the state of Louisiana promptly sued Roblox, claiming that its claims to protect kids on the site amount to consumer fraud. So what is going on here? And are we maybe missing a broader point about legal online child exploitation? Let's start by talking about the Schlepp situation. But first, okay, I'm not gonna sit here in front of God and the internet and pretend that I know a lot about online gaming. But I do know that there are some very specific laws governing how websites have to protect underage users. So at the risk of becoming a Hello Fellow Kids meme, let's talk about Roblox. It was created in 2004 by developers David Baszucki and Eric Cassell, released to the public in 2006, and now has over 100 million daily users. Roblox is an online platform that allows users to create immersive gaming experiences inside the Roblox metaverse and then play around in them with other users they can talk to directly. It's kind of like Minecraft, but with Lego avatars and Technicolor graphics and millions of ways to spend money. The majority of Roblox's users are children under 16, and it takes just seconds for a child to sign up. You don't even need to give Roblox your email to create an account, although you do have to submit proof of age to access some of the age-gated experiences on the site geared toward older users.
All right, this just showed up a few minutes ago. Exclusive for ages 17 plus games category. This shows up even before the popular page.
That's partly because, unlike a lot of free social media platforms, Roblox claims its primary monetization model is not hoovering up your personal data and selling it, although it does share that data with advertisers, which is totally different. Instead, Roblox's revenue relies on millions of microtransactions involving its internal currency, Robux. Users can buy Robux and spend them inside the game's ecosystem to purchase access to content made by independent developers, like digital clothing or cosmetics, or even full-blown premium games. Roblox was wildly popular before COVID, and after kids spent 2 years in their houses clutching their iPads as their parents tried desperately to get work done, it became ubiquitous. Chances are, if there's a kid in your life, 10 or under, what they want for Christmas is Robux. But all that is taking place in this space where there's almost no existing legal regulation at all. So it's probably inevitable that this would happen. What is going on here? There's a lot of sketchy people out there on the internet that you probably don't want knowing your home address, phone number, or the real names of anybody in your family who plays Roblox. And it's not surprising because data brokers vacuum up your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your personal data by signing up for today's sponsor, Incogni. Incogni removes your personal data from online data brokers by searching the internet, reaching out directly on your behalf, and forcing those brokers to take your personal info down. If the brokers resist, Incogni will take care of that too, because Incogni fights back. Those data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking how easy it is to find all this information. It also might be why you're getting so many spam calls lately or even had your identity stolen. I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni completed hundreds of takedowns for me over the years. I could never do this myself, so thank you to Incogni for weeks of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days with a 60% off discount and get a full refund if you're not into it. And if you keep it, you'll still get the exclusive 60% discount so long as you use our link or the code LegalEagle, all one word. So sign up for Incogni or we will see you in court. Roblox's users have long complained that the site does not adequately protect children from various abusive behaviors. Some of that is relatively minor. The site bans profanity, drugs, and the use of slurs through automated filtering and moderation. The trouble starts when Roblox players leave the site and interact via social platforms that Roblox has no control over, like Discord and Reddit. There are Discord servers and subreddits that connect players to condos on Roblox where avatars will hang out, shouting profanity, vaping, simulating sex, or whatever until the Roblox mods find it and shut it down. The website Fast Company describes digital gyrations, which are ridiculous if impossible to unsee. Thong-clad Roblox avatars twerking on stripper poles, beefy blonde avatars buck naked except for COVID masks, and enough crudely animated contortions to fill several volumes of the Kama Sutra should LEGO ever decide to publish an edition. The article by reporter Bert Helm tells the story of a 16-year-old he calls Hey, who struggled for 3 years, nearly his entire prepubescent life, to make a hit game on the Roblox platform, but never managed to stand out from the tens of thousands of new games that are uploaded to Roblox every day. There's that uncompensated underage labor again. So Kay shelled out 1,000 Robux on Discord for the complete code for a condo game, which would allow Kay to replicate it with a few tweaks each time Roblox's content moderators shut it down. He fired up a Discord server and a VPN, made a bunch of burner accounts, and loaded round after round of an illicit condo selling nearly 3,000 Robux, which he spent entirely on Roblox items. After a week, Roblox's servers identified his computer and hardware blocked him. Another 13-year-old was better at masking his identity and set up a thriving business creating similar naughty hangouts and hawking swag. He claims to have netted $150,000 a month in Robux, or roughly $500, depending on whether that included Roblox's 30% haircut. I mean, that's a lot of work for a relatively meager payoff. And while you wouldn't want your first grader wandering into such a condo accidentally, it's hardly child endangerment. If anything, it's more like the old Chuck E. Cheese where you'd spend hours and hours playing arcade games in front of weird gyrating animatronic figures to win tickets that you could eventually exchange for useless crap. And just like the underground Roblox condos, you could even smoke at Chuck E. Cheese. R.I.P. in peace to everyone's favorite rat from Coney Island. But Roblox's critics say the problem isn't confined to kids doing normal kid stuff and trying to squeeze a couple bucks out of it. The site's moderators left games like Escape from Epstein Island up for weeks despite the obvious reference to the notorious pedophile. And those critics claim that the platform is rife with sexual predators who seek out young children and entice them to other sites like Discord or Snapchat, or solicit child sex abuse material from children and pay them in Robux. They say that the platform doesn't do nearly enough to protect users from this predation. And there's at least some anecdotal evidence that that's true. Last year, Bloomberg Businessweek reporters Olivia Carville and Cecilia D'Anastasio published an article called Roblox's Pedophile Problem that told the story of a guy who went by the name Dr. Rofotnik on the platform and ran a popular experience called Sonic Eclipse based on Sega's Sonic the Hedgehog character. Rofotnik hired young kids to manage administrative and design tasks for him, paying them in Robux. Oh, hi again, child labor enriching a giant multinational corporation. Rofotnik was also sending wildly inappropriate messages to children, often misspelling words or adding spaces to evade censors. Rofotnik was outed by a YouTuber named Ben Simon who goes by the name Ruben Sim. Sim has his own complicated history with Roblox, but let's come back to that in a second. In 2020, Roblox banned Rofotnik and referred the case to the National Center for Missing and Exploited Children, better known as NCMEC. Under the Report Act, websites have a legal obligation to report the presence of child sex abuse material or potential sexual exploitation of children to NCMEC. And by the way, while pornography is protected speech by consenting adults, children cannot consent to sex, which is why we will be using the appropriate term child sex abuse material, or CSAM, here. The law requires companies which discover CSAM on their servers to report it to NCMEC, which Roblox did, but it didn't ban the Sonic Eclipse game, which Rofotnik just transferred to another user. Almost immediately, the Rofotnik character made a new account and carried on as before. It was only in 2021, when Sega filed a copyright infringement suit against Roblox, that they shut the game down. Now, Roblox maintains that it's an industry leader in keeping kids safe on its platform. Its CEO, David Baszucki, told WBOR in Boston that Roblox is the safest place for anyone on the internet. But content moderation is hard, especially when you're doing it at scale. And Roblox's management team has also said at a development conference last year that it intends to grow the platform to 1 billion active daily users and 10% of all global gaming revenue. How does Roblox intend to achieve astronomical growth and still maintain user safety? Oh, you know the answer to that one. They're going to do it with AI. But don't worry, Mom and Dad, because ChatGPT is on the case, and coincidentally, AI is a lot cheaper than hiring thousands of human moderators because you gotta protect that shareholder value, right? Now, back in 2022, 1 year after the site booted Rofotnik's original account, a 15-year-old girl in Indiana went missing. 8 days later, she was found in a filthy apartment in New Jersey, lured there by Rofotnik, who was actually a 22-year-old man named Arnold Castillo. Investigators discovered hundreds of messages between Castillo and the child, including her saying that she wanted to run away from home. There were images of their two avatars holding hands and wearing shirts that said boyfriend and girlfriend. In September of 2022, Castillo was indicted for transportation of a minor across state lines for sexual activity, and in May of 2023, he pled guilty and was sentenced to 15 years in jail. Roblox said the incident caused it to massively beef up its moderation teams and revamp its safety protocols, but the Castillo case is definitely not a one-off. In 2020, a 48-year-old Kansas man named Clinton McElroy, who was already a registered sex offender, paid an 8-year-old boy thousands of Robux to produce CSAM. McElroy is now serving a 40-year prison sentence in Florida. In fact, dozens of men have been arrested for using Roblox to approach young children for sex or sexual imagery, and at least 6 of those men were apprehended thanks to a YouTuber named Schlep. Schlep is a YouTuber who claims that as a child he was groomed for sexual exploitation on Roblox. As an adult, he produced multiple videos that feature avatars claiming to be young children engaging with predators online. The interactions moved to different sites such as Instagram, Discord, and Snapchat, and eventually the predators agreed to meet up in real life, resulting in sting videos that Schlep posts online for his 1.4 million followers. But on August 9th, Schlep tweeted that he'd been banned from Roblox. He posted a cease and desist letter he says was sent by the company, claiming that he violated its terms of service by engaging in simulated child endangerment conversations, sharing or soliciting personally identifiable information, and directing users to move conversations off platform. The letter accused Schlep of failing to immediately report suspicious activity to Roblox through proper channels, actively interfering with Roblox's established safety protocols, and exposing Roblox's users to increased risk. It threatened to sue him for breach of contract and violating the Computer Fraud and Abuse Act if he ever accessed the platform again. The CFAA is primarily a criminal statute, but it does allow for civil lawsuits against people who access computer networks without permission. On the company's site, Roblox's chief safety officer, Matt Kaufman, explained the decision to boot vigilantes off the platform. He says it's because they were impersonating children and actively seeking to connect with adult users. Those conversations mimicked inappropriate behavior and actively encouraged other users to connect on social media and messaging platforms, thus bypassing Roblox's own safety systems. Basically, they say that vigilantes like Schlep normalize this banned behavior by wandering around the website, engaging in it. And before you ask, no, that's not entrapment. Entrapment is when the government induces you to commit a crime, not some hyper-caffeinated keyboard warrior. Roblox also says that it violates the site's terms of service to not report predatory behavior immediately, which is not what's happening when you're filming your interactions so you can mine them later for clicks. Although the vigilantes would say that they do report the behavior and Roblox doesn't do anything about it. After the ban, Schlepp raced to make more viral content. He's now partnering with Chris Hansen, the former NBC Dateline reporter who hosted the long-running series To Catch a Predator, which filmed real-life vigilante sting operations, but for a national audience. Chris Hansen is stoked to shut up and play the hits.
Stay tuned. We're working hard on this project.
And Schlepp also hired lawyers, affiliating himself with 2 plaintiffs' class action firms, which together represent more than 400 individuals suing Roblox for harms they allege they suffered as minors approached on the website. Here's a recent case filed in Texas. It's clear that the lawyers are now circling the company looking for plaintiffs to sue Roblox based on various legal theories, including negligence, consumer fraud, and product liability. We also found this complaint Roblox filed against YouTube creator Ruben Sim for, among other things, posting false and misleading terrorist threats to discourage Roblox users from participating in in-person and online events, cyberbullying and harassing Roblox employees, accessing the platform after he'd been banned, and attempting to upload a nude image of himself with only a lampshade covering his genitals. It appears that that case was settled in 2022 when Sim agreed to pay Roblox $150,000 and stay off the platform. And I guess now is as good a time as any to state the obvious that child predators are bad people and companies should definitely keep kids safe online. And if you don't understand that, a law channel is not going to help you. But there are a whole lot of legal issues that go beyond the question of who is the bad guy here. So let's see if we can't break some of those down. Starting with the banning of Schlepp. Yes, the short answer is yes. Can platforms ban you? Yes. Can they do it for violating their terms of service? Yes. Can they do it for no reason at all? Yes. Do they have to apply their own rules consistently? No. And do you have any recourse if they don't? No. And the reason for that is Section 230 of the Communications Decency Act, affectionately known to its fans as the 26 words that created the internet. Under Section 230, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So if you post something obscene or defamatory on Reddit or Yelp or Facebook or Roblox, the companies that own those interactive online platforms cannot be held liable for what you said. That shield for third-party content is what makes social media and online interactive media possible. You couldn't have a functioning internet if platforms could be held liable for what users posted online. And then, you see where it says civil liability? No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So in plain English, a provider can boot you for any reason at all without civil liability. So yes, it may feel manifestly unfair or wrong or unjust, but that is the law of the land, and suing Roblox for unevenly enforcing its terms of service is not going to change that. Okay, so what duty do websites owe to child users? That is a harder question to nail down, and the answer varies across states. Obviously, websites have a legal duty to report CSAM to NCMEC, which Roblox does. It also has to abide by the Children's Online Privacy Protection Act, or COPPA. But COPPA is a data privacy law that governs how websites can store and collect data on users under 13. And Roblox doesn't collect that data at all, so that's not relevant here. And that leaves basic theories of tort law, like the ones all those lawyers are relying on, along with various other state statutes. Here's one that says the website violated California's consumer protection laws by claiming that it was safe when it is not. Here's one from Texas that says the company was negligent about child safety and committed fraud when it told parents the app was safe for kids. Here's one in Pennsylvania alleging product liability and breach of Pennsylvania's consumer protection statute. The issue here is that Roblox is going to assert Section 230 liability for user-generated content, which is why so many of these lawsuits focus on the fraud aspect, basically claiming that Roblox misrepresented itself when it had state-of-the-art technology to keep kids safe. And that's the basis of Louisiana Attorney General Liz Murrell's lawsuit against Roblox, which was filed on August 14th. She's alleging violations of Louisiana's Unfair Trade Practices Act, or LUTPA, along with negligence and nuisance. And I'm not saying that this lawsuit is doomed, but I am saying that it includes the most brain-meltingly terrible passage about COPPA ever put in print. She says, defendant could have also required children under 13 to provide their names and email addresses and obtain parental approval, a fundamental protection against predators, but refused to do so. This decision allowed the company to bypass certain protections that are mandated by federal law and designed to protect children. COPA was enacted because Congress recognized the heightened vulnerability of children on the internet. As the Federal Trade Commission noted, the limited capacity of children to understand fully the potentially serious safety and privacy implications of sharing their personal information. COPA bars companies from collecting and storing information about very young children, and I'm not here to stick up for Roblox, but the company didn't bypass COPA. It complied with COPA. It did not collect information from young children at all. But you know what jumped out at us when we dug into this case wasn't the content moderation problem, bad as it may be, because some percentage of those hundreds of tort cases are going to get in front of a jury, which will probably do more than any petition to encourage Roblox to fix its content moderation problem. There's one or two $10 or $100 million jury verdicts can do wonders to clarify the mind. What struck us is that Roblox is basically an $80 billion company town paying its employees in company script. The vast majority of the game's content is lovingly created by its players and placed behind a paywall. Roblox encourages users to become developers and create new content for the company by offering to share the profits. But Roblox Corporation pays those third-party developers in Robux. And Roblox prints that currency and can set whatever exchange rate it wants. And that exchange rate kind of sucks. Okay, let's do some back-of-the-napkin math here. If you are buying Robux, they cost roughly a penny each. Sometimes you can get them for less if you buy in bulk. Sometimes they cost more. But if you're a parent buying them for your kid, you're basically talking like $10 for 1,000 Robux. Now, if your kid spends that 1,000 Robux in a developer's game or experience, as Roblox calls them, Roblox takes a 30% cut off the top. The developer gets 700 Robux, but you can't spend Robux at the grocery store. You have to turn it into cash money. And while Roblox is perfectly willing to sell its in-game script for a penny, it's not offering that same deal on the back end. It will buy Robux from devs for 0.35 cents each, so like a third of the penny. And that's after the 30% commission it took on the original sale. So by my reckoning, of the original $10 forked over by mom and dad, the developer is getting $2.45. And if you're playing along with your calculator at home, that's only 24% of the original transaction. And developers are probably getting even less than that, since the Roblox platform has all kinds of upload fees and bank transfer fees and variable rates for players when they purchase Robux, and the point of sale cut in Robux isn't always 70-30 either. CEO David Baszucki makes a lot of fuss about how empowering this is for creators, particularly teenagers, and that's true. There are lots of very young creators on the site getting paid, and they're clearly willing to take what Roblox is offering, particularly since Roblox Studio provides so much back-end technical and creative support. It's also a pretty easy game engine to learn, so the barrier for entry is really low. But when Roblox brags about paying out $923 million to creators in 2024, remember that the company took in $3.6 billion during that time. And there are plenty of creators who made basically nothing. And while there are many adult professional developers on the platform, this is still an ecosystem that grew itself based on the labor of lots of very young people who cannot go out and get jobs in Silicon Valley and have no contractual relationship with the company and no real bargaining power. And these people are creating digital products for even younger consumers. So yeah, there's a problem when you have children who can't earn money running around a digital playground where all the fun stuff requires game tokens. That's clearly going to create a situation where adults who can earn money will prey on them. But that's hardly the only problem when you're talking about a multinational billion-dollar company that's paying those same children in Robux that they sell for a penny and redeem for a peanut.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? Or how do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.
Internet chatter about the TwitchCon situation is out of control. Last week, a thirsty fanboy rushed the stage at TwitchCon in San Diego and attempted to hug and kiss the popular streamer and queen of the weeaboos, Emiru. First off, gross. She's not your waifu. Second, see that guy? That's Emiru's personal bodyguard. Twitch's security team is nowhere to be seen. Her assailant was simply escorted out of the convention hall, and according to Emiru, Twitch did nothing further until her manager raised hell. Now, just in case you're not familiar with the fandom behind female streamers like Emiru and the intensity of the parasocial relationship, think of it like a modern Beatlemania, but with dudes in their 30s. It can get intensely scary. So predictably, the internet blew up with the overconfident legal hot takes regarding the civil and criminal liabilities from this breach of security.
Twitch is officially finished. At their convention, they essentially served up their top streamer to a predator.
There's a lot I want to talk about here after seeing what happened at TwitchCon last night, which is textbook assault.
One of the most popular streamers, Emiru, was sexually assaulted.
Most of these takes are flat out wrong, or at least woefully incomplete. So who's really on the hook here for this awful situation, and what charges could they face? Well, my job as a lawyer, but more specifically as a prosecutor, is to follow the facts to the most reasonable conclusion. So today, I'm going to break down what we know about the TwitchCon situation, explain how a prosecutor or a plaintiff's attorney would approach bringing the liable parties to justice in this case, and who should be the most concerned about lawyering up. So everybody just calm down, and let's sort out the TwitchCon drama before it gets any uglier.
Today, I'm finally going to be opening up about the psychological and domestic abuse, stalking and harassment, sexual assault, and threats of blackmail that Ms. Kiff has done towards me, and some of these issues which are still ongoing.
After the streamer Shen Andygens released the video of the assault on Twitter, it amassed millions of views. It prompted TwitchCon to put out a statement proclaiming that they had immediately blocked this individual from returning to the TwitchCon premises, and they are banned indefinitely from Twitch, and that the safety and security of all those attending TwitchCon is our highest priority. But Emiru wasn't buying it, and posted a scathing response on Twitter. According to her statement, a similar incident occurred the previous year. A stalker was harassing her, compelling her bodyguard to grab his arm and forcefully bring him to law enforcement. Twitch's response to the incident was to ban her go-to bodyguard.
There was a stalker and he held him by the arm until police got there. And because of that, he was indefinitely banned from TwitchCon.
She goes on to place a lot of blame on Twitch for failing to protect her, especially because there were several TwitchCon security guards nearby who did nothing to help her when the incident occurred. These are facts that do not seem to reflect an organization that truly places safety and security as its highest priority. Further, according to Emiru and the video evidence, the man was just allowed to walk away.
The behavior displayed by the individual involved in the incident yesterday involving a high-profile streamer was completely unacceptable and deeply unsettling. In line with existing TwitchCon security protocols, law enforcement event security were on site. That's a lie. That's literally a lie.
She said she only heard about him being detained hours later and that TwitchCon only apprehended him because her manager pushed for it.
They're trying to find the guy. They haven't found him. I'm like, what?
She claims to have learned that Twitch was only going to give the attacker a 30-day ban from using the site, that is, until her manager objected to the anemic punishment. And then a few days later, Emiru issued another statement telling her viewers that she'd talked to the police and they were working on a warrant, but were being stymied by Twitch's failure to cooperate with them.
When I got a phone call from the San Diego police, and they were talking to me, and they basically said, hey, we can't really do anything right now because They apparently know the name of the guy, but they're not giving it to us until a warrant goes through.
Now, we'll talk about Twitch and the liability that they may face in a moment, but plenty of other influential streamers echoed Emeru's alarm bells against TwitchCon's lax security, including the VTuber Iron Mouse.
How many times does bad have to happen in order for people to start taking it seriously and start waking the f up and start protecting people and start offering better security for people? What if that was your sister? What if that was somebody from your family? Imagine the person you care about the most going through that.
If you don't know why it matters that Iron Mouse is calling TwitchCon unsafe for creators, then good for you. You know the touch of grass. But for the rest of you men of culture, you know that VTubers and three-dimensional streamers alike have a reasonable expectation that Twitch will protect their identity and ensure a reasonable level of safety from all the degenerates in chat. These are the most critical factors for them to do their jobs as entertainers. So Twitch is not off the hook here, but the extent of their liability depends a lot on what a thorough fact-finding investigation discovers about the TwitchCon situation and what crimes or civil torts Emeru's assailant actually committed, which are not as straightforward as the internet would have you believe.
Sorry to interrupt, Scout Owl, but assault by a toxic parasocial fan is a great reminder that now's probably a good time to wipe all your personal and private information off of the internet. Because your cell phone number, home address, email address, private social media accounts, and tons of other sensitive data are shockingly easy to purchase by anyone online. But you can fight back and take control of your private information by signing up for today's sponsor, Incogni. Because Incogni wipes your personal data from the internet by searching online, reaching out to data brokers and websites directly on your behalf, and forcing them to remove your private information. If they resist, Incogni will take care of that too, because Incogni fights back. But what makes Incogni truly powerful in taking back control of your privacy is their custom removals feature. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people's search sites. Now, I've been using Incogni for years now, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me in that time. Now, I could never do this myself, so thank you to Incogni for weeks worth of work in adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you scan the code on screen or click on the link in the description, you'll get 60% off their unlimited annual plan, or try Incogni risk-free for 30 days. And if you decide you still want to keep it, you'll still get these 60% off discounts as long as you use my code LegalEagle, all one word, at checkout. So sign up for Incogni, or I'll see you in court.
Okay, let's watch the clip again, paying special attention to what the guy does and when. Emeru alleges that in this moment, Thirsty McThirstface here tries to kiss her. The internet was quick to proclaim this as sexual assault, and this is totally understandable. If a random guy charges forward, grabs you, and tries to forcibly kiss you, that really seems like sexual assault, and in some ways it is. The problem, though, is that California's statute on sexual assault is pretty specific. California uses the common law term battery to refer to an assault that results in some form of touching. So California's sexual assault criminal statute is actually titled sexual battery. California Penal Code section 243.4 subsection E1 states the following: any person who touches an intimate part of another person, if the touching is against the will of the person touched and is for the specific purpose of sexual arousal, sexual gratification, or sexual abuse, is guilty of misdemeanor sexual battery, punishable by a fine not exceeding $2,000 or by imprisonment in a county jail not exceeding 6 months or by that fine and imprisonment. Now, 6 months in jail or a $2,000 fine seems pretty insufficient for sexual battery, but that's not the only problem here. Under California law, the attacker has to touch an intimate part of the person. And the law defines intimate part very narrowly, as the sexual organ, anus, groin, or buttocks of any person, and the breast of a female. In her statement after the fact, Emeru said,
and then he grabs my face and he leans in and lips puckered tries to kiss me, and I start screaming.
From the angle of the video, it's hard to tell where the attacker's hands were, but since Emeru didn't mention that he touched her anywhere but her face, we're going to assume that that's the only place he touched her. So he grabbed her face and tried to kiss her. Does that qualify as sexual battery? Well, under California law, an attempted forcible kiss wouldn't qualify as sexual battery because the attacker has to touch an intimate part of another person. In fact, even if the attacker had managed to kiss her, it may not qualify as sexual battery because lips and faces aren't included as intimate parts of the body under section 243.4. His actions were offensive, threatening, and unacceptable, but because of the technicalities of California's law, he likely won't be liable for sexual battery or attempted sexual battery. It's important to note that sexual assault laws are really jurisdictionally specific. Soccer, or football, fans may recall that a few years ago, the head of Spain's National Soccer Federation forcibly kissed a member of the women's soccer team after their World Cup victory.
Rubiales kissing Hermoso on the lips, a kiss, she said, that was not welcome. The Federation chief brushing off initial questioning about the advance.
He was later convicted of sexual assault by Spain's High Court. So if TwitchCon had been held in a different state or country, Emery's attacker potentially could be charged with sexual assault or an attempt to do the same. But this happened in California, and that's that. For what it's worth, prosecutors probably wouldn't have a hard time convincing a jury his actions were principally motivated for the purposes of sexual arousal. Sure, he could always argue that he was just so enamored with Emery's wholesomeness that his cringy kiss attempt was nothing more than G-rated affection, a type of I did it for the mouais offense. But come on, that doesn't pass the smell test. Again, if you don't know what that word means, good for you. But what about non-sexual assault and battery? Well, our favorite Florida man and de facto Jesus of the internet had this to say.
There's a lot I want to talk about here after seeing what happened at TwitchCon last night with Emiru being assaulted by a rogue lunatic fan who just walked completely unimpeded past the line at her meet and greet and unconsensually hugged her and looked like tried to kiss her, which is textbook assault.
So is this textbook assault? Is this battery? Again, under common law, assault is generally the attempt to touch someone, and battery is the actual touch. California Penal Code Section 240 defines assault as an unlawful attempt coupled with a present ability to commit a violent injury on the person of another. There was clearly an attempt to kiss her, and obviously the attacker had the ability to follow through with that. He was only stopped, belatedly, by Emeru's security guard. But does a forcible kiss qualify as a violent injury? As it turns out, California courts have a long history of agreeing that a forcible kiss does qualify as a violent injury under California's assault law. In a 1907 California Supreme Court case called People v. Bradbury, the court quoted a criminal justice manual that stated, "The kind of physical force is immaterial. It may consist in the taking of indecent liberties with a woman or laying hold of her and kissing her against her will." Since then, many California courts have affirmed this. A California appeals court found that violent injury doesn't just include bodily harm. It includes any wrongful act committed by means of physical force against the person of another, even though only the feelings of such person are injured by the act. This means that the person who is attacked doesn't have to prove actual physical harm. They just have to show that there was an attempt and ability to cause some kind of harm. So it seems like Emeru has a pretty strong case against her attacker under California's assault law, which carries a maximum penalty of 6 months in jail and a $1,000 fine. That's a misdemeanor and highly likely not to result in any jail time or minimal jail time. But she also may be able to claim battery. Under California Penal Code Section 242, a battery is any willful and unlawful use of force or violence upon the person of another. This one seems pretty clear-cut. Emeru's attacker forcibly grabbed her body. She may not have been actually physically injured, but the law doesn't require that, just an unlawful use of force. Under California law, battery carries a maximum penalty of 6 months in jail and a $2,000 fine. So not much different than the penalty for assault. Now, before you go on thinking that California doesn't take assault and battery seriously, these statutes are not that different from most jurisdictions, and they simply represent a base level of criminal liability. In any assault or battery case, the factual circumstances can, and often do, enhance the severity of the punishment. A prosecutor likely has a case here, and Emeru has said that she is pressing criminal charges against her attacker.
I am pressing charges against the guy with the police.
So, to get a criminal conviction, the prosecutor will have to show that the attacker is guilty beyond a reasonable doubt, which doesn't seem super difficult here since there were dozens of witnesses and the video that you just saw. But Emeru may also be able to pursue a civil lawsuit against her attacker, which would be even easier to win because there's a lower burden of proof. She only needs to show that he's guilty by a preponderance of the evidence that is more likely than not. If Emeru does decide to file a civil suit against her attacker, she can claim actual monetary costs she incurred, like therapy, increased security expenses, legal expenses, disruption of her normal day-to-day activities, etc. But she can also claim punitive damages in a civil suit. That is, a certain amount of money she feels entitled to because her attacker did a crime against society itself and ought to be punished for it. And she can also potentially make a claim for intentional infliction of emotional distress. To do that, she'd have to show that her attacker intentionally and recklessly did something that caused her to suffer emotional distress. Generally, the person's actions have to be outrageous to meet this threshold, but grabbing and forcibly kissing a stranger sure seems to be outrageous. And Emru wouldn't be the first female celebrity to file a civil suit against a convention attendee who broke the rules. During a 2013 meet and greet, DJ David Mueller groped Taylor Swift's backside. When Taylor complained and he was fired from his job, he sued her for defamation. She countersued him for assault and won a jury trial, which proved that unwanted touching is indeed assault. So if you're the creepy Twitch guy and you're watching this, you need to lawyer up ASAP, because you're likely to face 2 separate cases, one criminal, one civil. And frankly, the lawyers on the other side are better than you can afford. But maybe you can ask your mom for some cash when she brings your dinner down to the basement. Now, many of Emru's fans have also urged her to sue Twitch for failing to protect her, and Emru herself had some pretty scathing allegations against the company. But how much is Twitch actually liable for failing to protect her? Well, it depends. As Emru's manager noted, Twitch was pretty negligent.
She's like, okay, I've been talking to Twitch people, and I'm really upset because I noticed a lot of negligence around the event, and I'm not happy with the way that they're handling it now.
Commenters on Reddit and Emru's channel agreed. If I were Twitch CEO Dan Clancy, I would lawyer up now and prepare for a lawsuit, because it looks like Emru has a pretty good case. Let's pull the video back and talk about why. So this is the first problem. This guy just walked right past the line and no one stopped him. And here's the next problem. No one from event security intervenes once he's grabbed her. And the final problem, even after he grabs her, event security apparently just lets him walk away. Civil liability in this context centers around the question of whether the defendant had a duty to the plaintiff. Generally, people aren't legally required to protect others from harm caused by third parties, but there are exceptions. One is the special relationship rule. If a special relationship exists, a person or business might have a duty to protect someone from others' conduct. Courts often find this in situations like a shopping center, restaurant, or bar, and its customers or tenants. Because of this, business owners must take reasonable steps to keep common areas safe from likely criminal acts. One of the most important parts of this is foreseeability. If a criminal act is foreseeable, then the business has more responsibility to try and prevent it. And as many people online have pointed out, Twitch had plenty of reasons to believe that Emru might need some extra security. At a prior TwitchCon, she'd been followed around by a fan who stalked her around the venue. And that's why her main security guard was banned, because he'd intervened on her behalf and muscled the little simp into the arms of police.
2 years ago, where there was a guy following me around TwitchCon, and he asked him to stop multiple times. My guard asked him, and the guy wouldn't stop. So he grabbed the guy, but he didn't hurt him. He was just holding the guy until the con security came.
Also, kind of crazy that Twitch banned that guard forever, while, at least according to Emru, they only banned her attacker for 30 days. Also consider the fact that in March of this year, a stalker followed Emru around and made death threats to Emru and fellow streamers Valkyrae and Cinna on camera during a live streamed event. Because of this, several prominent streamers like Valkyrae, Pokimane, and QT Cinderella have said they weren't sure they wanted to attend TwitchCon because they weren't sure they would be safe there. If a business knows about prior criminal activity, courts have said that the business needs to provide heightened security. So legally, Twitch ought to have known that she needed extra security and should have provided that. But courts generally weigh this foreseeability against the burden created by additional security measures. And hiring security guards is considered really burdensome because it's very expensive. So California courts don't usually require ordinary businesses to do that. At a large event like a convention, though, the crowd size and fame of the featured creators tips the balance in favor of requiring the event host to hire security. And as a lot of commenters noted, the parasocial relationships created by Twitch heightens the threat even more. Twitch's best defense is that it did hire security guards and screen the people in its meet and greet line. But as Emru pointed out, the event security guards did nothing when she was attacked, and screening meant little when each meet and greet attendee was allowed to bring an unscreened +1. So even those measures were pretty lax. Twitch's guards let this guy just walk right up past the line of registered attendees. Then they did nothing when he grabbed her in front of a room full of people. The only person who acted was Emru's own bodyguard, shoving the guy away from her. So I bet some of you might be wondering whether he could be liable for manhandling the goofy gooner. The honest answer is, it depends. To review, for assault, there has to be an attempt to commit a violent injury on a person with the ability to follow through. And for battery, there must be a willful or unlawful use of force against a person. For Emru, she has a strong case that she was the victim of both assault and battery. But what about the other guy? Let's watch that clip again. That looks like a pretty serious shove, but it also looks pretty justified. Remember though that Twitch banned Emru's other bodyguard for forcibly restraining a rabid fan at a prior con. So maybe Twitch thinks this is the assault it needs to punish. This was definitely a use of force under California's battery statute. But under California law, like most jurisdictions, there are some scenarios where assault or battery is allowed, such as self-defense or defense of others. California's jury instructions for assault specifically state that if someone acts in self-defense or to defend a third party, that's not assault. The jury instructions for battery are similar, with one additional caveat. If someone uses force to defend themselves or another person, they can only use force that is reasonably necessary to defend against the danger. So Emeru's bodyguard couldn't say, pull out a gun and permaban the dude from this mortal coil. But shoving him away seems pretty reasonable under the circumstances. It was necessary to get the man to let go of her and back off, and it didn't cause any injury. Some might credibly argue that more force would have been warranted. On the other hand, if he hadn't acted, could Emeru's bodyguard, like Twitch, be liable for failing to protect her? An ordinary bystander wouldn't typically be liable for failing to intervene in this situation, but a bodyguard might, because bodyguards have a higher duty of care than the average person does. They've been specifically hired to protect that person. So if they fail to do that, then they're not just bad at their job, they're also potentially civilly liable. This generally means that security guards have to use reasonable care and attention to protect people and property, act responsibly, and help keep the environment safe. From the video, it's pretty clear that Emeru was being attacked. As Emeru noted in her public statement, she screamed loudly. Any reasonable bodyguard should have interpreted this as a situation where they needed to intervene, just like her bodyguard did. It was his job to protect her, especially against such an obvious threat. If he hadn't acted, especially since he was standing so close, he also could have been liable. So Emeru's bodyguard is probably in the clear. He did his job. But still, probably a good idea for him to lawyer up, just in case. Lawyers need work in this economy. Twitch, if you believe them, are also taking the situation seriously and have promised to do a full investigation and review their security standards and practices accordingly. And Emeru's got a long road ahead to fully resolve the TwitchCon situation, but it wouldn't surprise me if she decides to bring suit against Twitch. This was, after all, her last TwitchCon ever, as she proclaimed during the fallout.
Regardless, like I said, I'm done with going to TwitchCon. Probably done entirely with convention streams. I feel like it's just time, you know. And I think that's probably true for a lot of streamers. The climate has, you know, really changed.
And who knows, maybe we'll all be treated to the surreal sight of Iron Mouse taking the witness stand. But there's just one more thing to address, because in all the fallout of this, something else came out. In her October 25th video, Emeru talked more about the TwitchCon attack, but she also made some other quite serious accusations against her ex-boyfriend, fellow streamer and OTK owner, Mizkif.
Today, I'm finally going to be opening up about the psychological and domestic abuse, stalking and harassment, sexual assault, and threats of blackmail that Mizkif has done towards me, and some of these issues which are still ongoing.
Fans have long speculated that these two dated each other, and it turns out that they did, and it was a total mess. In her video statement, Emeru claimed that she had already talked to a lawyer. Good for you, Emeru. This is one of the most important steps for anyone in an awful situation like this. She accused Mizkif of engaging in a bunch of scary behaviors, including sexually assaulting her one night on her couch when she was crying and he put her hands down her pants. Let's pause on that incident for a second. This took place in Texas, so the law is a little different from California. In Texas, the relevant statutes are Texas Penal Code sections 22.011 and 22.012. Section 22.011, sexual assault, requires penetration, but section 22.012, indecent assault, can just be a touch to an intimate part without someone's consent. It's gross that we even have to talk about this, but unfortunately this is the world we live in. Like California, Texas specifies what is considered an intimate body part. Putting a hand down someone's pants would definitely qualify as indecent assault under section 22.012. And Texas's 10-year statute of limitations for indecent assault shouldn't be a problem. So if she wants to make a police report, she can. And she could also follow up with a civil suit, which again requires a lower standard of proof. Emeru also made a variety of other accusations, that he manipulated her, screamed at her, threatened her staff, and threatened to engage in some kind of weird smear campaign claiming that she was murdering her own pet rabbits. In a response video, he admitted that he was controlling, but denied most of the rest of it.
In regards to being controlling, I told her many things. I told her to dress older, to stop wearing pajamas, to stop talking about stalkers and schizos as a whole, stop talking about past relationships, and yes, I didn't want her to travel without me.
He also claims that, quote, I'm ashamed that the situation got so bad, but Emmy was also violent. She would throw clothes or plushies at me, and I'd punch holes in the wall or slam doors in aggression. Which Kind of seems ridiculous, to be honest, especially in the face of serious sexual assault allegations. But technically, and I'm going to stress technically, throwing a stuffed animal at someone could qualify as assault under Texas law. In Texas, a person commits assault if a person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse, intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. Why that third clause doesn't specifically include the person's spouse, I don't know, but that's Texas law. So okay, again, technically, throwing a stuffed animal at someone could be assault in Texas if it makes contact and it's offensive or provocative. But come on. I cannot imagine a prosecutor charging that ever, even in Texas. Also, I'm gonna hazard a guess that these were Kirby plushies, which is sad. Kirby didn't want any of this. Interestingly, Ms. Kiff's admission to punching holes in the wall could also be assault. It depends on how close he was to her and whether under the circumstances it could be proved that it constituted a knowing threat of imminent bodily injury. These are important details that police and prosecutors would look at during a criminal investigation, or lawyers during discovery if it's a civil suit. But the next obvious question is whether she should be worried that he'll countersue her for defamation. Since she says she's already talked to a lawyer, she's probably made sure that she has her bases covered on this one, but in short, if her accusations are true, that is a total defense against defamation. She claimed to have receipts, and even showed a long list of crazy texts from him during her stream. Also, since he's a public figure, that will make it harder for him to make any kind of defamation claim, because generally speaking, public figures have to prove that the statement was not only false, but that the person who said it was acting with malice. That's a pretty high standard, brought to you by the First Amendment. So Emeru is probably in the clear on any kind of defamation counterclaims, and she might have some valid criminal or civil claims against Miskiff if she decides to pursue them. But she should probably keep chat out of the loop until the matter is litigated or resolved. So we can only hope things get better for Emeru soon, and that Twitch makes some serious changes to its safety protocols. Because, unfortunately, chat has an increasingly long history of not being very poggers about obeying the law.
Thank you, Scout Owl, for that analysis. And if you watching at home are accosted by a fan or get into an auto accident or suffer a personal injury, I do know a great lawyer. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.